Well, Stephen, thanks very much for joining us tonight for the Civil Rights Roundup.
Thanks for having me, Cam.
My pleasure. So what are we going to be talking about this evening?
It's a sad case. It's a case of Dina Esteban versus Commonwealth of Virginia. The background here is, at the time when the incident occurred, Ms. Esteban was a 43-year-old, married, mother of two, had never been in trouble with the law, typical of these stories, law-abiding, decent citizen. She was employed as an art teacher at Marumsco Hills Elementary School in Prince William County, Virginia, and she taught at that school for 11 years. And like many other law-abiding citizens, Virginia residents, she had applied for and possessed, she received and possessed a valid Virginia concealed carry pistol permit. And she got that permit and carried the concealed pistol for self-defense and when she went out alone. And one evening, Ms. Esteban went out shopping, and it's nighttime, it's dark. Her husband can't go with her, and so she places her lawfully owned, lawfully purchased .38 caliber revolver in her handbag that she carried that night. Go shopping because again she's by herself. It's nighttime, and remember she's got a concealed carry permit. It's all lawful. Now here's where the problem is. The next morning she goes to work, but unfortunately, she'd totally forgotten that she had placed the pistol, the revolver in her handbag, and so purely by accident, without any unlawful intent, she grabs her handbag in the morning and goes to work with it, and just completely forgot she had the revolver in her handbag, which she put there the night before when she went shopping. That day, at school, at her workplace, in addition to her class, she had agreed to teach a class that was not her own, doing somebody a favor. So Miss Esteban leaves her classroom, takes her handbag, and she's got an armful of art supplies, because, again, she's an art teacher, art supplies, construction paper, a cardboard box filled with all sorts of stuff, a large old coffee can, those big ones, containing scissors and glue, and she heads to the classroom of a teacher colleague who is a special education teacher and teaches a special education class. And there, Ms. Esteban was scheduled to teach a group of 11 special education students, and 10 of these kids were in wheelchairs, one walked with a cane, and the special education teacher, she would be in attendance and would also help with the art lessons. There were also 3 teaching aides present. So we got 5 adults, and 11 kids who are 10 of them in wheelchairs. One can't walk without a crutch. And when she got to when Miss Esteban got to the special ed teacher's classroom, she put the art supplies down for the lecture, on the desk, and placed the handbag in between the sink and the wall. And Cam, at all times, that handbag was inaccessible to the students in the room because of their disabilities. 10 of 11 being in wheelchairs, they could not maneuver towards the bag. They couldn't get to the bag even if they knew what was in the bag. And Miss Esteban taught her lesson. Took about an hour, and then she's got all this stuff. The box, her big industrial coffee can, the art supplies, and all that stuff. She grabs all that stuff. She's juggling that stuff around and takes all that stuff with her to go back to her own classroom. But she forgets about the handbag. She leaves that handbag between the sink there and behind the sink, and totally forgets about it. Now, after she left, the special ed teacher noticed a yellow handbag sitting in the corner of her classroom, behind the sink there. And not knowing whose it was, the special ed teacher, she decides to open it to, see if she can figure out who it belongs to. And upon opening it, she sees some money, a checkbook with Esteban's name on it, and the revolver. And the special ed teacher then, kind of freaks out. She shows the gun to the teaching aides, and she puts the gun back in the handbag and takes it directly to Miss Esteban. And the special ed teacher then confronts Miss Esteban and tells Miss Esteban that she had found the handbag in her classroom. And the special ed teacher then asked Miss Esteban if the handbag was hers, and Miss Esteban, of course, truthfully responded that it was, that it did belong to Miss Esteban. And the special ed teacher then told Miss Esteban that she had opened the bag and she'd seen the handgun, and Miss Esteban was shocked. And later at the trial, the special ed teacher described Miss Esteban's reaction as, quote, in shock, probably how I looked when I opened it and saw the gun in there, unquote. So even that testimony from that special ed teacher, who turned her in, was that Miss Esteban was obviously in shock. And Miss Esteban stated, quote, "Oh, my God, I forgot it was in there, oh, my God," unquote. And Miss Esteban told the special ed teacher that she had completely forgotten that she had the gun in the back and that she never brings a gun to school, but that she did have a concealed carry permit. It was a legal gun. She had a concealed carry permit. She just totally forgot.
Yeah.
Now, the special ed teacher told Miss Esteban that she needed to get the gun out of the school immediately, and Miss Esteban, of course, did that. She left the school immediately with her handbag and the gun. Now, that evening, while Miss Esteban was at home, a police officer comes to the door and asks her about whether she had a gun in the school that day. Okay, so not only was there problems at school, but the school or the special ed teacher informed the police. And Miss Esteban, when the police officer was there, was in shock, and the police officer then asked her if she owned a gun, and Miss Esteban replied, "Yes, I do own a handgun," and she presented the handgun to him, and the police officer then immediately grabbed the gun and confiscated it, without her consent. But in the end effect, the fact was no one got hurt. There had been no criminal intent. This has all been an unfortunate accident. Ms. Esteban had never and would never do anything to deliberately put the students in harm's way. But still, this had something to do with a gun, and the local prosecutors, they were bent on sending a message because this involved a gun. And despite acknowledging that Ms. Esteban showed no criminal intent, the prosecutors threw the book at her. The very next day, that night, the cops come, they seize the gun. The very next day, she's charged with a felony for possessing a firearm in a school under Virginia's firearms-free school zone law. Now, Ms. Esteban contacted the NRA's office of the General Counsel, our office, and we gave her a lawyer referral, to an attorney who's listed in our attorney referral list. And again, listeners, are free to call our office or contact our office for an attorney referral. And the attorney we referred to was Richard Gardner, who's a private attorney in Virginia who specializes in firearms cases, and he's one of the attorneys on our attorney referral list. And by the way, Richard actually used to work in the office here with me in the General Counsel office. He worked in the General Counsel office for years. Then he had also been NRA ALA's legislative counsel and director of the NRA ALA state and local division years back. Now, besides giving Ms. Esteban the referral, the NRA Civil Rights Defense Fund also funded her case. Okay, now back to the case. In the criminal court of the Circuit Court of Prince William County, Ms. Esteban's attorney filed a motion to dismiss, and he filed that on the grounds that Ms. Esteban had not knowingly broken the law. And such a defense has been upheld in cases before. Mm-hmm. In fact, common law, British common law, where we get our law from, it required such a what's called, quote, mens rea, unquote, as an element in felonies. And the U.S. Supreme Court has ruled that such an element, of mens rea, of proving knowing conduct, as opposed to an innocent act, was, and here's the U.S. Supreme Court's rule, quote, the rule rather than the exception to the principles of Anglo-American jurisprudence, unquote, at least when it comes to felony cases, okay? Mm-hmm. And Mr. Gardner argued that the state had to prove that Ms. Esteban had knowingly violated the law and that she should not be found guilty of a felony because of an entirely innocent mistake. I mean, she had no intent to bring the gun to school. Now, the prosecution, on the other hand, they argued that Ms. Esteban's intent mattered not at all because they argued this was a, quote, strict liability, unquote, offense. And a strict liability offense is one where the defendant's intent or even the defendant's knowledge doesn't matter at all. The legal theory is that, this is a case where society is so concerned with the prevention of this very evil wrong that it wishes to maximize the deterrent value of the offense, and that society wants to punish even people who do so innocently. Okay? And in such a case, to be convicted of such an offense, the defendant need not mean to or to commit the offense, and the defendant doesn't even need to be aware that he or she has committed the offense or the act that constitutes the offense. Now, Ms. Esteban's counsel, Richard Gardner, attempted to argue that this particular offense, possessing a firearm in the school, was not a strict liability offense, and he stressed the fact that Ms. Esteban had no idea that she had brought the gun into school, and that as soon as she discovered the fact that she did unintentionally bring the gun to school, that she immediately removed it from the premises, okay? Mm-hmm. And also, of course, again, there was no harm at all done. There was even no possibility, really, of harm. But the motion to dismiss was denied by the court. The case then went to a jury trial, and, the jury convicted Miss Esteban and sentenced her to a year in jail and a $2,500 fine and 2 years of probation. Okay? Now, unfortunately, the judge suspended the jail term, so she didn't have to spend a year in jail with rapists and murderers, And Miss Esteban's attorney appealed the case to the Virginia Court of Appeals. The Virginia Court of Appeals upheld the conviction. And then Ms. Esteban's attorney filed a motion for a rehearing en banc with the Virginia Court of Appeals. That was denied. And then Ms. Esteban appealed the case to the Virginia Supreme Court. But, unfortunately, the Virginia Supreme Court also upheld the conviction. Bottom line here is that Ms. Esteban, a law-abiding citizen, a teacher who'd never been in trouble with the law before, taxpayer, like I said, veteran school teacher, art teacher, mother of two, a wife, well, she's now a convicted felon. And this sentence has wrought havoc on her life, okay? First, she's fired from her job as a teacher, okay? Then her former colleagues ostracized her, okay? She's been unemployed since all this happened.
Oh, man.
And here's her comment, quote, she gave this comment, "People think I'm some kind of dirtbag," unquote. She can't find employment as a teacher because of this conviction, and she's been effectively blacklisted. Good luck getting a job, at a school when you got to answer a question. Have you ever been convicted of crime? You got to admit you're a convicted felon.
Yeah.
Now, all of this is because she made an innocent mistake. She'd forgotten that she had a gun in her back, which she brought to work. And also as a convicted felon, she's also now disqualified, what's called a disqualified person under both federal and state law, who's banned forever from possessing or even touching a firearm. And, this overzealous gun control policy has also robbed Ms. Esteban of her privacy and personal dignity. She, as a convicted felon, she cannot travel out of state without permission. Her DNA is registered in the state database. The police have released her home address, phone number, and mugshot to the media, when all this happened. Yeah, and financially, she lost her job, and her husband, Philip, had to start working 2 jobs to support the family and to cover legal expenses. And, Philip Esteban said this, quote, "This was clearly a political prosecution. It's bizarre beyond comprehension that he can be convicted of merely possessing something that's constitutionally protected," unquote. That's what he thought. Now, Ms. Esteban's prosecution is not unique, okay? More than 30 states have criminalized possession of a firearm on school grounds. There's also a federal Free School Zone Act, Firearms Free School Zone Act, which makes it a felony to possess of firearms on school grounds. Now, at the time that Ms. Esteban was being prosecuted in Virginia, Renee Rutnick, a special education teacher in Kent, Washington, was put on trial also for accidentally taking a gun to school that she obtained to protect herself after suffering domestic violence and abuse. Okay, like Ms. Esteban, Ms. Rutnick, a 30-year veteran teacher, was a licensed legal concealed weapons permit holder, a law-abiding, tax-paying citizen. Now, fortunately for her, there was a different type of jury. This jury refused to convict her. But, even though Ms. Rutnick was not convicted by a jury, okay, she, too, lost her job, okay? But, Cam, there's a question that we got to ask ourselves is, are schools safer when the state bans teachers from possessing firearms? And I would say no. The fact is that those sick people, like the cretins at Columbine, more than 10 years ago, like the fellow at Virginia Tech, those criminals are assured that their victims are defenseless and that they can have their way with their victims, in a gun-free environment, because the criminals are not going to care about that law, but the victims are going to be disarmed.
Yeah.
And these madmen, they're bent on destruction. They pick a place where you're assured that the victims are rendered defenseless by gun control laws. You never see these guys attacking a U.S. Army base, or a gun club.
Right.
They go to places where they're assured that their victims are unarmed. And Cam, a few years ago, I think it was 2003 or so, a student at the who had failed his classes and was kicked out of the Appalachian School of Law came to the school and killed the dean, a professor, and a student, and wounded 3 more students. But, he was eventually stopped and subdued by 3 students, okay? Now, the media reported that. What they didn't report is that 2 of those students, the good guys, were able to stop the bad guy because 2 of those students had run out of the school down the driveway off school property to retrieve their guns from their cars. Okay, because they could not. The reason they had them in the cars is because there was a gun-free school zone, and they couldn't bring their guns to school. Now, then, when they ran back to the school with their guns, they were able to subdue the attackers with their guns. Okay, with their legally owned guns. And you got to ask. Now, technically, they were violating the gun-free school, rule.
Right.
But you got to ask yourself. In that situation, 3 people died and 3 were wounded. But could more people have been saved if the 2 good guys with the guns had been allowed to have them on their person instead of having to run out to their cars, get the gun out of their cars, run back to the school and confront the guy? Could more students have been saved at Columbine? If one of the teachers had been allowed to be armed.
Mm-hmm.
And if we take a look at the recent examples of the Colorado law, where University of Colorado prohibited guns on campus, and Colorado State did not. In the one school where it's prohibited, crime has risen. In the school where guns, concealed carry permit holders are allowed to carry guns, crime has dropped dramatically.
Yeah.
Dramatically.
Absolutely. Hey, Stephan, thank you again, sir, for joining us on the program, and look forward to doing this again next week.
My pleasure, Cam. Looking forward to it.
Stephan Thomas, Deputy General Counsel of the National Rifle Association, joining us here on Cam and Company.